Welcome back to this third segment of Contract Law Frustration. Before the break, we were looking at situations where the doctrine showed exactly where the limitations lie, and we will carry on in similar vein in this segment. Now, there will be no frustration, the courts consider, where there is an express provision in the contract which covers the intervening event. So, for example, if there's a force majeure clause, that will take precedence. But a force majeure clause will be interpreted narrowly. And the case, of course, is the one we have looked at earlier, the Metropolitan Water Board and Dig Car Limited. Because the idea is, if the parties have considered the possibility of a supervening event and they have made provisions for that, then clearly the idea of contract is not to disturb what it is the parties have agreed. Again, freedom of contract. So it will not in any case, for example, cover trading with an enemy, but you will have no there'll be no frustration, or the courts will find that they'll find there's no frustration where there is an imprudent bargain. Again, freedom of contract. The fact that you have agreed in circumstances where you find later on that it is detrimental to you will not be sufficient to support an order from the court based on the doctrine of frustration. Now, Taylor and Caldwell, we see foreseeability where the risk was foreseen by one party. Frustration will also not exist where the frustrating event should have been foreseen. Case in point, Walton Harvey Limited and Walker and Humphreys Limited. Now that case in 1931 was about a hotel owner who entered a contract with an advertising agency, enabling them to put up illuminated adverts on the roof of their hotel. Now the hotel was then compulsorily purchased by the local authority and demolished. Clear frustration there in my view. The advertising agency sued for breach of contract, and the hotel argued the contract had become frustrated. The court said the contract was not frustrated as the hotel owners were aware that the local authority were looking to purchase the hotel at the time they entered the contract. They should have foreseen the fact that this could happen in the lifetime of the contract and made provisions in the contract for such an eventuality. They were therefore liable to pay damages for breach of contract. The point is, when you look at frustration, it is such that if you're able to plead it successfully, you will be able to arguably get an order from the court that says that neither party are liable for any obligations under the contract. But if you are unsuccessful, so if the court says, well, no, we don't see frustration on these, it means that you have now committed a repudiatory breach, which means that you're liable. So it doesn't go to frustration, you are then liable in the circumstances. Another case where we see something similar or something along those lines is the Peter Cassidy Seed Company case in 1957. And there, the claimant, who was an English company, purchased some ants' eggs from the defendant in Finland. The ants' eggs required an export license. After agreeing to the sale, the defendant was refused the license. The claimant brought an action for breach of contract. The defendant argued the contract was frustrated, so they were not liable for breach. Now the court said the defendant should have foreseen the possibility of the license being refused, and therefore the contract was not frustrated because it was not a foregone conclusion. You're going to have to apply for a license. The fact you have to apply means you may get it, you may not get it. So you should have foreseen that before going forward. So there will be no frustration also where the frustration is self-induced. So if by your own actions you then get into a situation where the contract is impossible to perform, the courts are unlikely to assist you. A contract will not be frustrated if the impossibility is the fault of either of the parties. Okay, that's another way of saying it. So if we look at a case called Maritime National Fish and Ocean Trawlers, which is a 1935 case, we see there that the claimant owned 5 fishing vessels, one of which was chartered to the defendants. Now, the fishing vessels were all fitted with otter trawler nets, and new legislation was introduced requiring licenses to be held by those using otter trawler nets. The claimant applied for 5 licenses, but was only granted 3. He had to name which vessels the license would be used on. He named his own vessels and excluded the vessel which the defendant was using. Now, this meant that the defendant was unable to use the vessel for fishing. The claimant sued the defendant for the price of hire, and the defendant, in his defense, stated the defendant had committed a breach in not providing a license, so he was not obliged to pay for the cost of the hire. The claimant argued there was no breach, as the failure to provide a license was a frustrating event, in that the decision to grant licenses rested with the Secretary of State. Now, the court said the contract was not frustrated, since the claimant had chosen to keep the 3 licenses granted for himself rather than using one to fulfill his contractual obligations. He had therefore induced the frustrating event and was therefore in breach of contract. So as far as the courts were concerned, if you decide to get the 3 licenses, then use them on your boat and then rent out the one that doesn't have one, and then of course say, well, frustration. Court said no, you have now breached your contract. Now, if there exists a force majeure clause as well, as I said before, this will apply rather than the law of frustration, and the clause must actually cover the event which occurred. What effect then does frustration have on a contract? Well, where the contract is found to be frustrated, both parties are released from their obligations under the contract, and neither party may sue for breach. Because if you notice, as I say, the whole idea and the reason why you'd have a defendant saying that there is frustration, it would be because if you manage to plead that there is frustration, you would certainly not be liable as it relates to any obligations, and therefore you have basically got into a position where, well, there's nothing I can do, I'm not liable anyway, and you walk away from it. Whereas if you unsuccessfully plead frustration, it means you are still in the frame, you're still liable, and you have to pay on the contract because you would then have breached. Now, frustration automatically discharges a contract from the date of the frustrating event. So future obligations are discharged, but rights and obligations are incurred, which were incurred before the frustrating event remains. And this will be important when we come to look at the remedies. Now, what is the effect of frustration? Well, it tends to come in one of 3 forms. There's severability, which means that if a part of the contract is frustrated, then you may be able to save the rest of the contract if you're able to sever that part of it that is frustrated. So let's say, for example, I'm renting you, for example, for a wedding, the gardens of a stately home, but let's say this stately home has been burnt down, but you can still use the gardens, and possibly you just needed the stately home simply for changing in, for argument's sake. If that is the case, can you still use the gardens? Is it possible for the contract to be severed? If it is, then you can. Now, you can also look at its effect at common law and also by statute. Now, at common law, the contract was terminated automatically and immediately, and both parties were released from their future obligations under the contract. However, they were required to fulfill any obligations which fell due before the occurrence of the frustrating event. So, for example, what it meant was that the loss lay where it fell. In other words, the contract was not void right from the outset, but only from the occurrence of the frustrating event. Now, you need to contrast that kind of position with the effect of mistake, which overrides the contract rights from the beginning. Now, this led to, of course, unfortunate consequences. And in a case called Appleby and Mars in 1867, what had happened was that the plaintiff there had undertook to erect machinery upon the defendant's premises. Now, the work was to be paid for upon completion. When the work was almost completed, both the premises and the machinery already erected were destroyed by fire. It was held that the contract was frustrated. However, the plaintiff could recover nothing for the work done since the obligation to pay didn't arise until completion. Pretty harsh. But if you look at Chandler and Webster 1904, the plaintiff agreed to hire from the defendant a room in Pall Mall. It was along the line of cases to do with King Edward VII's coronation procession. Well, the price was £141, payable immediately. The plaintiff paid £100, but of course, before he could pay the balance, the procession was cancelled, as we've seen in Crellin Henry and in Herne Bay. The plaintiff sought to recover the £100 paid. Now, the Court of Appeals said that not only did he fail to recover his £100, but he was also liable to pay the balance of the £41 as an obligation which fell due before the occurrence of the frustrating event. Now, Chandler and Webster in particular provoked much judicial criticism and was eventually overruled to some extent in the Fibrosa. Now, in the Fibrosa, we touched on that earlier, where we see the situation there with the war and the ability there where when it comes to a point where you're looking at a government action or something which you have no control over, then arguably you'd be looking at a frustrating event. We will take a brief break, and when we return, we will conclude with this session on frustration, and after the break, we'll conclude.